Welcome to Heritage Foundation. I'm Andrew Parks, the Program Coordinator for Lectures and Seminars. Thank you for joining us today in our Lewis Lehrman Auditorium. I wanted to take this opportunity to remind folks watching in-house to turn off cell phones as a courtesy to those recording today's program and to our panelists. Those watching online are welcome to submit questions by emailing speaker@heritage.org. And hosting today's program is John Malcolm. He's the director, and Ed Gilbertson and Sherry Lindberg Gilbertson, Senior Legal Fellow in the Edwin Meese III Center for Legal and Judicial Studies. So with that, John.
Thank you. Thank you very much for being here, and I applaud you hardy souls who braved the cold weather today in order to be here. We are here today with several distinguished panelists to talk about a fascinating book. It was a fascinating book about a fascinating case, National Federation of Independent Businesses, NFIB, versus Sebelius, better known as the Obamacare case. And as I read this book, I thought that I was really watching some very, very smart people who obviously respect each other, but who are in no way, shape, or form shy about challenging each other. And they would advance and refine their arguments as the book progressed, covering many facets of the Obamacare case, some of which they will discuss today. I will introduce all of the speakers in the order in which they will speak, and we're going to start off with Trevor Burrus. Trevor was the editor of A Conspiracy Against Obamacare. He is a research fellow at the Cato Institute Center for Constitutional Studies, where Trevor's research interests include constitutional law, civil and criminal law, legal and political philosophy, and legal history. Trevor got his undergraduate degree at the University of Colorado at Boulder and his law degree at the University of Denver Sturm College of Law. In addition to providing a brief overview of the book, Trevor will also talk a little bit about how some of the current problems that we've all been reading about with respect to the Affordable Care Act relate to the case. Next, we'll hear from Professor Ilya Somin. Ilya is a professor at George Mason University's School of Law, where his research focuses on constitutional law, property law, and the study of popular political participation and its implications for constitutional democracy. He got his BA degree from Amherst, a master's degree from Harvard, and his Juris Doctorate from Yale Law School. Following graduation from law school, he clerked for the Fifth Circuit Judge Jerry Smith. And in addition, by the way, to A Conspiracy Against Obamacare, I will gladly put in another plug. Ilya is the author of another book here, Democracy and Political Ignorance, Why Smaller Government is Smarter. And his articles, by the way, have also appeared in many scholarly journals. Ilya is going to discuss competing constitutional visions that were at play in the case, and also about the role of the Volokh Conspiracy in terms of influencing the debate that surrounded the case. After Ilya, we will hear from Oren Kerr. Oren is the Fred C. Stevenson Research Professor of Law at George Washington Law School. He got a BA from Princeton, a master's from Stanford, and his Juris Doctorate from Harvard. After graduation, he clerked on the Third Circuit for Judge Leonard Garth and then on the Supreme Court for Justice Anthony Kennedy. Oren is a nationally recognized scholar in the areas of criminal procedure and also computer crime law. He worked for a while, in fact, at the Department of Justice's Computer Crime and Intellectual Property section. He's argued many cases throughout the country, including the U.S. Supreme Court, and his articles have appeared in top legal journals and, in fact, in many judicial opinions. Oren, whom Randy Barnett described as a one-man moot court with respect to this debate, will discuss what role academics and commentators played in the run-up to this case, and he will compare that with the role that academics and commentators have played in other Supreme Court cases. And last but certainly not least, we will hear from Randy Barnett. Randy is the Carmack Waterhouse Professor of Legal Theory at Georgetown University Law Center, where he teaches on a whole variety of subjects. He is a graduate of Northwestern University and Harvard Law School. He began his career as a prosecutor in the Cook County State's Attorney's Office in Chicago. In 2004, he argued argued the medical marijuana case, Gonzalez versus Raich, before the Supreme Court, and that case actually featured rather prominently in terms of the analysis for the Obamacare case. He's the author of over 100 articles and law reviews, as well as 9 books. And Randy will discuss the role that politics played in the litigation. So with that, please join me in welcoming our panel, and then we'll turn it over to Trevor. Up to you, wherever you'd like.
Actually, I'll stay seated. Well, thank you very much, John, and thank you to the Heritage Foundation, both for putting this on and for helping out incredibly throughout the litigation of this crazy case. I also want to thank the Volokh conspirators, 3 to my left here, and some who aren't represented, David Bernstein, Dave Kopel, who was my professor in law school, for giving me the opportunity to work on this book, which was incredibly fun. Got to relive some of my own past, because I had the interesting experience of coming out of law school and immediately working on the biggest Supreme Court case in 50 years. So that was somewhat surreal, thanks to working at the Cato Institute. I'm just going to give a few brief comments about the way that I always saw this case. And I lecture about this throughout the country, and sometimes I feel like I have to return people to rudimentary civics class. And maybe a lot of the problems we have with the Constitution as it stands today is because people forgot civics class from 7th and 8th grade, particularly politicians who view the Constitution as an impediment to making the world awesome, which is pretty much often what they do. First, I want to discuss, just so we have a frame of reference here, the way the law works now, or doesn't work, as the case may be, but the general theory behind the law. It's really important to realize this so we can talk about the future dysfunctionality of the law and how this plays into the way the case worked out. So the Obamacare is I would call it a political subterfuge built on 3 pillars in order to create the functional equivalent of a single-payer system while still calling it a market. Now, what do I mean by that? Well, first, it's a political subterfuge. How is it a political subterfuge? Well, they didn't say that they were taxing you for this. They just made you give your money directly to a private company. Now, why did they have to do that? Well, because they told these private companies, the private insurers, that they had to cover pre-existing conditions at a price-controlled rate. So you're an insurance company, and you're told you have to cover all pre-existing conditions, and you can't charge more for that. And you're going to say, hey, what about the money? We need some money. And the government has a few choices. One, they could directly subsidize the insurance companies and raise taxes accordingly. Or the other, they could participate in a political subterfuge and make you purchase insurance so they wouldn't have to raise taxes. This is a huge part of the law. It's unquestionably part of the subterfuge. If you look at the CBO's scoring of the law originally, the CBO has a way of scoring where sometimes if you take control of an industry too much, they'll consider that part of the cost of the bill. And the way that this worked is that they asked the CBO, while they were drafting the law, they said, how much of a percentage of what's called a medical loss ratio, which is how much the insurance companies can spend on administrative costs, how much of that would make you include the cost of the individual mandate in the bill? And they said 89.5%. And then the law said, all right, 89.5%. That's exactly, we're going to put it right there so you will not include the costs incurred by individual people in the bill. So then what happens next? Well, everyone has an idea maybe of the death spiral, which is the next thing that you get out of this. You need people to spend more money on insurance than they would otherwise. This is not a bug in the law right now. Everyone's saying that. This is a feature in the law. There's no way it could work otherwise. You have to pay more for insurance than you would otherwise for things that you generally wouldn't cover yourself, so you can subsidize the newly sick people who are going to be consuming more health care. The Obama administration's biggest mistake in this law was not selling it as a redistributionist law. People are going to start finding out over the next year that this is a redistributionist law, and the reason they're paying more is exactly in the law. It is not a bug, it is a feature of the law. And that is going to come back and bite them in the 2014 election in particular. So that's what the individual mandate does. It subsidizes the rest of the costs of the law. Now, there are some direct subsidies and some other taxes, and I won't get into the 2,700-page law, but that's a general idea. So the next question is, what they're going to talk about more is, can Congress do this under the commerce power in particular? And I won't get into more of the nuances of the way decision worked out. But going back to civics class, I always thought this was very simple. And I was recently lecturing to a bunch of Germans about this, and they were saying, as you get from Europeans a lot, well, what's wrong with having more health care? What's wrong with this being the case? Why are Americans so against Washington, D.C. having this better healthcare system. Your healthcare system is so bad. If you have any European friends, perhaps you've heard this before, and you have to say, no, the way you're thinking about this is wrong. The question you have to ask yourself is, as a German, how would you feel if Brussels took over your healthcare decisions? Not Berlin, but Brussels. You'd be like, well, no, Brussels doesn't have power over that. Well, why doesn't Brussels have power over that? They kind of have power over commerce, and all of the laws of Germany affect the other laws of the EU. So why doesn't Brussels have power over healthcare? And that's the question that we dealt with hundreds of years in our jurisprudence in our Constitution, was the idea that commerce is a type of thing and not a zone of effects. Now, it's very difficult to understand exactly what type of thing that is. Is it manufacturing? Is it local agricultural laws? But whatever it is, it's a type of thing. Increasingly, the government said it's a zone of effects, and we need control over all zones, all effects in this zone in order to make our carefully crafted schemes work better. That's the way the Commerce Clause expands. And that will happen in Europe. I mark my words, it will happen in Europe. The drug laws of Amsterdam, the manufacturing laws of Germany, all those are impediments to some sort of crafted scheme coming out of Brussels to rationalize the entire European economy. And when they come to us and say, well, what do we do about this? Brussels is saying that these local laws are an impediment to commerce. We say, well, yes, they are, because you can't make that argument. This was the difficult problem. If someone comes along and says, we have power over individual people who have not purchased health care because they have an effect on commerce, the only thing we can say is, yes, they do, or duh. It's the only thing we can say. You have to articulate a vision that says individual people not purchasing health care is the type of thing that commerce does not apply to, whether or not they affect the economy. Because if your power extends to affecting the economy, it's limitless. And we did win that battle, and they'll talk more about that. And I just want to make a few last comments about where we are going forward. It wasn't much publicized the day of the decision, but it wasn't a win for the Obama administration in many, many ways. The second worst thing would have been for the law to be kicked out. The second worst thing was for the Supreme Court to give choices to people to purchase health care or not, and states to expand Medicaid or not. That was the second worst thing that could have happened. Because as I've explained the law, the way it works, now the way that the Supreme Court articulated it is the mandate is like a no parking sign that isn't actually a no parking sign. It's a you can park there and then pay the fine. And that means that the CBO had to reassess the law because they know that it no longer has the legal command of what it needed to work, even if it was going to work. So that was the worst thing that could have happened, and that's going to make this law spin out of control faster than before. The challenge we have going forward is to articulate a vision that says the reason this law didn't work was not because they didn't have enough power, is because they took too much. That is the road to serfdom argument that Hayek talks about. That is the fight we're always in. After this law fails, the next question will be, well, the reason it failed is because the Supreme Court gave them choice, and that's a loophole. And they gave the states choices, and that's a loophole. And there wasn't enough power, and those are all loopholes. But in this context, the loopholes are your freedoms. And freedoms are not loopholes in a system of limited government. And that's the fight that we have to win going forward when this law does and will collapse. Thank you.
Might be easier.
Sure.
I'd like to start by thanking the Heritage Foundation for organizing this event and all of you for braving the elements to come here, and also my fellow panelists, and especially Trevor for doing all the hard and painful work of editing dozens and dozens of blog posts, which is certainly not an easy task with so many obstreperous people like us involved in the project. Getting lots of academics to cooperate together in a book is a little bit like herding cats, only perhaps even worse. So in my talk, I'd like to start by focusing on the clash of constitutional visions that this case represented, and then I'll go on to talk at the end about the role of the Volokh Conspiracy in the public debate over this issue. I think ultimately this case developed into a clash between two competing visions of the Constitution and federalism. On the one hand, you had what might be called the New Deal or post-New Deal vision, which is held by probably the majority of legal academics, and many other people also, especially those in the political left. And it holds that, especially after the New Deal, Congress has and should have the power to regulate virtually anything that affects the national economy in any way. Otherwise, claims this vision, we simply wouldn't be able to deal effectively with a modern, complicated, interconnected economy. And in particular, in addition, this stuff should be left to the political process rather than the judges for many different reasons, including the fact that they don't have the bureaucratic and administrative expertise in a way that Congress does or a federal bureaucracy does. On the other hand, you have an opposing vision which says that Congress should be limited by the list of enumerated powers that is enumerated in Article 1 of the Constitution, and that the judiciary should enforce the boundaries of those powers, and it also holds that it's actually a good thing in the real world to enforce those boundaries because having a federal government with too much power is actually harmful rather than beneficial. And I think it rapidly became clear that the debate over the individual mandate in particular was in fact an unavoidable clash between these two competing theories of how to interpret the Constitution, because the argument for the mandate under the Commerce Clause is the idea that Congress can regulate people who have no health insurance and force them to buy health insurance. Why? Because not having health insurance in the aggregate affects the national economy. And the problem with this argument is, of course, that the same thing could be said for any decision to do anything or not do anything anywhere else in human life or in American society. For example, it certainly applies to the famous broccoli analogy we discussed during the debates over the case and is discussed in our book. If you choose not to purchase broccoli, that certainly has an effect on the market for food and other parts of the economy. If you choose not to exercise regularly, that will likely reduce your economic productivity and also have an effect on the economy. And I can make the same analysis for pretty much anything else that you can think of. And therefore, this core argument for the mandate essentially had no limits. Moreover, it also made many of Congress's other powers in Article 1 of the Constitution redundant. For instance, if the power to regulate interstate commerce enables Congress to regulate or restrict anything that might have an effect on the economy, then Congress doesn't need the power to coin money. After all, coining money has an effect on the economy. It doesn't need the power to raise armies. Raising armies certainly has an effect on the economy. And I can say similar things for virtually everything else on the list of Congress's enumerated powers. Now, recognizing this problem, the federal government and other defenders of mandate tried to make a series of what in the book I call healthcare is special arguments. They're saying, well, this is a special market that's different from anything else. In the book, we go through all of these here. I'll just mention the one that was most often made. Healthcare is special, it was said, because unlike with most other products, everybody must purchase it at some point in their lives. Now, to some extent, this is true, but notice that the focus has shifted from health insurance, which is what you're actually required to purchase, to health care, which is just a broader category. By the same kind of bait and switch, I could also justify the broccoli mandate. Not everybody likes broccoli as much as I do. Many people do not purchase it, but everybody is in the broader market for food, of which broccoli is just one part. The market for food, in fact, is even more difficult to avoid than the market for healthcare. Just try avoiding it if you don't believe me about that. And I can make a similar analysis for purchase of virtually any other product. Maybe, unlike all of us, you don't read the Volokh Conspiracy, but you do get information through some source somewhere. You're all part of the broader market for information, so we can justify a mandate requiring all of you to read the Volokh Conspiracy every day by the same kind of reason. I actually kind of like that idea. Maybe we should have that mandate. So you get the point. While the government created various clever and sometimes not so clever healthcare as special arguments, ultimately they fell apart under close inspection. Now, I'd like to next talk about an aspect of the case that got a lot of attention from legal experts, but I think less from non-experts, and that is the necessary and proper clause. Even if the mandate was not authorized by the Commerce Clause alone, maybe it could be authorized by the Commerce Clause combined with the necessary and proper clause. the latter clause gives Congress the power to enact any laws which are necessary and proper for carrying into execution other powers granted to Congress. And going back all the way to the famous 1819 case of McCulloch v. Maryland, the Supreme Court has defined necessary extremely broadly as anything that is useful or convenient, and we knew going into the case it was very unlikely the Supreme Court would overrule that definition of necessary, even though I and others such as James Madison and Thomas Jefferson have had some problems with it, but we weren't going to win on that. However, we felt, and there's a lot of evidence to support this, that the necessary and proper clause requires not only that the law be necessary, but also that it be proper. And that actually is what several of the founding fathers said at the time. The Supreme Court has said it previous to this case as well. Question is, well, what does proper mean? In a brief that I developed on behalf of the Washington Legal Foundation, we argued that at the very least, proper means that you can't justify a law by logic that would give Congress virtually unlimited power, or as James Madison put it much better than I could, whatever meaning this clause may have, none can be admitted that would give an unlimited discretion to Congress. And as it turns out, the federal government's theory of the necessary and proper clause under the case would in fact give them that exact unlimited discretion, and that's why actually 5 justices ended up rejecting their necessary and proper argument and actually gave the most thorough treatment of the proper aspect of the necessary and proper clause that Supreme Court has actually ever given in its 200-year history. They concluded that proper may enable you to create a sort of ancillary power to one of the enumerated powers, but not to create a, quote, great and independent power. In other words, necessary and proper clause can be used to pin a tail on a dog, but not to pin a dog on a tail, which is essentially what the federal government was trying to do. And much more could be said about this, but I think this is actually one of the more important parts of the Supreme Court's decision, one that deserves more attention. I discuss a lot in the book, but I also have a separate article which I've written about this. Now, finally, in the last couple of minutes that I have, I'd like to briefly talk about the role of the Volokh Conspiracy in this debate. Part of it was that some of the arguments used by the people challenging a mandate were in fact first developed by some of us at the Volokh Conspiracy, especially by Randy Barnett, who was, according to the New York Times, the godfather of the constitutional case against the individual mandate. But I think perhaps an almost equally important role of the VC was in breaking down the perception that the other side of this debate was trying to create, especially at the start, that virtually all experts agreed that the mandate was clearly constitutional. So if you thought that it wasn't constitutional, either you were sort of like an ignoramus who just didn't really know anything about constitutional law, or you were a partisan hack. So you were a hack for the GOP or for some kind of interest group, perhaps. And I think the Volokh Conspiracy helped break this down because early on, we put out a lot of arguments against the constitution of the mandate, and people like Randy Barnett, David Kopel, and John Hadad and others, being prominent constitutional law scholars, they could not be dismissed as either ignoramuses or hacks, and therefore, over time, many people, including many people who didn't agree with us, had to recognize that there was a real debate here as opposed to just a slam dunk for the federal government. Moreover, the blog format enabled us to influence this part of the debate in a way that we might not have been able to through traditional means for a couple reasons. One is the Volokh Conspiracy, thanks in large part to the work of Eugene Volokh, who was not much involved in this case but did found the blog. It had a large pre-existing audience among legal scholars, journalists, and others who were influential in this debate. Secondly, because we could post almost instantly anytime we wanted, we could respond in real time to claims that were made by either side in this debate. And that gave us tremendous advantage over doing things through conventional media or through writing law review articles, which are great. I write lots of them myself, but they take many months to come out, and very few journalists or non-experts are likely to read them. Now, I certainly would not argue that the Volokh Conspiracy was the only factor in this debate, or even necessarily the most important. It clearly was not. In the book, we discuss many other factors that were relevant, both political and legal, but I do think this is an interesting example of the blog blogosphere having a significant influence over a debate related to a Supreme Court case, and I suspect that similar things are going to happen in the future, and it'll be interesting to see how this technology develops over time and how it continues to influence legal debates. So on that note, I conclude, but I very much look forward to your questions. Thank you so much.
All right. Thank you to the Heritage Foundation, in particular to John Malcolm, for the invitation to be here to talk about the book. I wanted to pick up where Ilya had left off, talking about the book and the posts that make up the book as blog posts, and sort of ask what were we doing when we were writing those blog posts? Because I think there are ways in which the blog format are changing the nature, or at least some aspects, of Supreme Court advocacy and blending some old categories. So I wanted to think about the blog posts here as blog posts that made up the book, and think about how blogs in particular may be changing the constitutional debates, with really the material in this book being just one example, maybe the first public example of how this might happen. And I was what led me to think about the book this way is I happened to have the page proofs for the book on my desk at the same time I had an article about Yale Commissar. Some of you may be familiar with Yale Commissar, emeritus professor at the University of Michigan, who's a real giant in my academic field, criminal procedure. In the 1960s, when he was a young academic, he wrote a series of law review articles really rethinking some of the basic understandings of the nature of constitutional criminal procedure, which had been very narrow up to that point. And he came along and said, I think we're reading these cases wrong. I think we're reading the history wrong. I think we should start to think about a new role for the Supreme Court. And he laid down in a series of articles published in traditional journals, and in some cases in chapters in books, new ways of thinking about kind of constitutional possibilities. For example, the Miranda rights, the Miranda decision in the 1960s, in part reflecting an idea that Yale Commissar had, that the Fifth Amendment should not be limited to the courthouse. It should also apply in the station house during interrogations. And that was the argument that Commissar had laid out. And there was a sense that you have, going back looking at Commissar's articles from the 1960s and then the Supreme Court decisions that followed, that Commissar was playing a role in changing the terms of the debate. The academic voice was saying, well, here's a new possibility, and then, good enough, so 2 or 3 years later, the Supreme Court would come out with a decision, often citing Yale Commissar, in some ways echoing the ideas that he laid out. And that was an example, I think, of an academic sort of engaging in what you could consider something like advocacy support, sort of a way of pushing the courts, opening up the courts to new possibilities. And in that case, it was basically, to put political labels on it, a liberal academic pushing a liberal Supreme Court in a liberal direction. And I think there are ways in which what we saw with the blog post at the Volokh Conspiracy is kind of the mirror image of that. Conservative academics opening up new conservative, again, just putting labels on things just for the sake of expedience, pushing the law, offering ways of pushing the law in a more conservative direction. And so I think there's a prior example of some of the ways in which this dynamic occurred before. And what's interesting to me is the ways in which the dynamic are different, even though there's some similarities there. One aspect, and one that Ilya had mentioned, is just the time element. So looking back at the 1960s, Commissar would write an article, and then it would come out a year later, and then there'd be a case 3 or 4 years later, and sort of, it was maybe a 5-year time window. And the internet just changes all of that, right? So one change which it's worth reflecting on, which to us just seems obvious today, but was stunning 20 years ago, is the fact that you can even get opinions quickly. When I was in law school in the mid-1990s, and at the time it was still mostly waiting for slip opinions from the library. It'd take a couple of days, or it would take weeks or months for West to come out with the opinions if you wanted to know what a court had held. And of course, today it's instantaneous, right? In fact, it's frustrating, if anything, if a judge releases an opinion at 10 o'clock, and sometimes you have to wait until about 10:15 or 10:30. You're sitting there hitting refresh. Why is this opinion not in front of me yet? This is outrageous. And then there's a sense, if you're a tenured academic and you have a lot of free time, you think, well, I want to write on this opinion, and I've got to get my opinion out, and you think in terms of minutes or hours, not in terms of days, weeks, or months. And so this debate, as Ilya had suggested, has really become instantaneous. And the counterpoint is instantaneous too, right? So you can have, looking through the blog posts in this book, many of them were on the same day, or over a period of 2 or 3 days. And so effectively the debate is occurring in real time and in a very public way. This is sites that anyone can read, and in a site like the Volokh Conspiracy that's built up a readership over more than a decade, you can have a lot of law nerds that want to follow the debate over new cases can go and read about it and read the counter arguments. And if you're really, really bold, go through the 500 comments. I say really, really bold. And you can wade through the comments, you can add comments, comment on comments, sort of as many debates as you can have, all in real time. And the speed element is new. So I think one fascinating aspect of this case is how the perception of the arguments and the arguments themselves were kind of morphing in real time. Public attitudes about the arguments were changing in real time. It was just happening really, really quickly. And I suspect that that's this is an example of how it's going to be. This sort of the new world we're in. And what's the second point I wanted to make about this is that blogs allow an interesting mix, not only of the role of scholar and advocate, but scholar, advocate, and litigant. So there was a 2009 law review note in the Stanford Law Review called Ex Parte Blogging, which raised some interesting questions about the ethical limits under the legal ethics rules of blogging. And the author, Rachel Lee, had the following concerns. Well, if you have a blog that folks in the legal community are reading, and you have sort of an infinite resource of electrons to offer to any particular case, by the time the briefs are filed, the briefs can kind of be an afterthought. It's the blogging that may actually set the terms of the debate, and if only one side is blogging, then one side essentially sort of gets to file infinite briefs, right? They could just keep writing about it, and are there limits on one side's ability to blog about a case, given that blog posts can be kind of amicus briefs or even merits briefs in disguise? And I tend to think those concerns are overblown, because ultimately it's a public site and it's just people discussing a case. And in the same way that somebody could write an op-ed or have a press conference about a case, blog posts are kind of an extended version of that. At the same time, I think you can have, in very high-profile cases, blogs really changing the nature of debates on pending cases. In that if there are blogs that a lot of people in the legal community are reading, you can have posts that kind of change the understandings of issues and sort of debate issues in ways that, I remember when I was a Supreme Court law clerk, I clerked in 2003 to 2004, I read blogs, and my sense was pretty much the other law clerks did too, because we were the kind of people that were really interested in pending cases. And if you're a law clerk and there's a blog post about a case that you're working on that day, you're probably going to want to be interested in reading it to see if there's something that might be relevant to what you do. You don't have to, obviously, but it's out there, and you might find it. So we're seeing kind of an interesting blend where, as I said, the merits briefs become yet another round of briefing in what can happen in sort of the blogosphere as a public debate. And I think in the Affordable Care Act case, that was an example. The briefs filed in the case were fantastic briefs. But if you'd followed the blog posts for a long time, there was a sense in which they were kind of repackaging and slightly altering arguments that had been debated in the public sphere for a long time. And I suspect that that's just, again, going to be something that we have happen more and more in the future. And I kind of wonder what Supreme Court litigation is going to look like in 20 or 30 years. You could have kind of the official blog of the case, right? And then there's the briefs, and isn't that quaint? Those legal briefs that are filed in a case. And Justice Scalia will only read the brief, and hopefully on the court. He'll scoff at these blogs that are out there. But you can imagine others will say, well, if I want to know the extended version of the argument, I don't want to have the page-limited version, or I'm really interested in a specific issue. Look, there's actually a series of blog posts on this specific issue. You can go to that if you want to know more. So I don't know if we'll have official blog posts for a particular case, or there will be like the DOJ blog where they get to offer their version of this, or they don't have their own version. But I wonder if blogs will actually play this broader role. To my mind, ultimately, that would probably be a good thing, because if you don't want to access it, you don't have to, of course. The briefs will always still be there. But it's another voice out there, and it's more information, which hopefully will lead to better informed opinions by the courts. But I do think it's a change here, and that we're seeing more and more of a blend of these roles. In the Volokh Conspiracy, the Affordable Care Act case, I think, was probably the example now of this blending of roles, leading to the briefs being just one of many parts of the public conversation. So thanks for hearing, and we'll look forward to Randy.
Well, thanks so much. I can't resist noting that you are now sitting in a historic location. You are sitting in the location where the first public arguments against the constitutionality of Obamacare were aired, in this very room, in the Heritage Foundation, in December of 2009. I was on a program organized by the Heritage Foundation in which we presented the paper that we wrote for Heritage in 2 weeks, arguing for why the Affordable Care Act was unconstitutional, which had not even come out of committee at this point, or had just come out of committee. And it was a paper that I wrote with Todd Gaziano of the Heritage Foundation, and very importantly, Nathaniel Stewart, who was then a legal associate who helped do some of the heavy lifting on the drafting, as legal associates tend to do. And we wrote this paper that we presented in this room. I remember meeting Orrin Hatch in the green room right outside the door here, because he was the keynote speaker. First he spoke, gave a wonderful speech about why the act was unconstitutional, mirrored most of our arguments. And then I had a debate about it, and I obviously argued that it was unconstitutional. And who did the Heritage Foundation dig up to argue that the law was constitutional? It was none other than Eugene Volokh, the head of the Volokh Conspiracy, the founder of the Volokh Conspiracy. I always thought that one of the reasons why we never heard from Eugene during the course of the debate, one way or the other, is because he was already on record in this debate as arguing that it was constitutional, and he just sort of wanted to stay away from the subject from then on in as the argument developed. But anyway, this all happened in this very room, and Heritage Foundation deserves a tremendous amount of credit for what happened in terms of the challenge. The other thing that's probably less well known than the fact we had this public event here was immediately after the public event, we went upstairs to a lunchroom in which we briefed congressional staffers on the argument. And this was crucial because up until this point, although the Senate has a procedure in which you can make a point of constitutional order to object to the constitutionality of the bill, it was not clear that the Republicans in the Senate were going to make such an objection, because it was not clear that they knew why the bill might be unconstitutional. And it was during the briefing, the private briefing we had for the staffers upstairs in this building, in which we laid out the argument that subsequently, shortly thereafter, the Senate Republicans did make a point of constitutional order. There was a televised debate on C-SPAN, which brought to the public for the first time the arguments that were against the constitutionality of the Affordable Care Act, in which at least several senators relied on the Heritage Foundation paper making that argument. So it all started here, and here we are again. So before I say much more, I just want to point out something that hasn't been said up till now, and I'm kind of glad it hasn't, because it leaves me something to say, and that is that this is a terrific book. It's just a really good book. I was getting ready this morning, and I was trying to psych myself up to participate and everything. So I went back and I decided I would just read a little bit of the beginning to remind myself what was in here. We were all working on the pages and the manuscripts. This was actually some time ago, and I started reading it, and I couldn't put it down. I just kept reading it, and it wasn't only my own stuff I was interested in reading either. I mean, although I like that stuff too, but it wasn't just me. It was just a fascinating read. And so I want to urge people who think, well, okay, fine, I've watched the program, now why should I read the book? The book is really interesting debate that is just inherently interesting and dramatic as you see it evolve and the emotions that are coming out of these various blog posts as we debate each other. But also, you will learn a lot about constitutional law. It is like a tutorial on constitutional law. As you read one argument, then you read the counter-argument, then you read the counter-counter-argument. When you walk away from this book, you're really going to understand constitutional law a whole heck of a lot better. In part because Orrin, who's immediately to my right here, served as the protagonist. He was our resident House skeptic. He was the person who didn't buy any of the arguments we were selling, and he was just absolutely persistent in objecting his dissent in a very, very powerful way, and just made us refine our arguments and present our arguments. If it hadn't been for his contribution, the book just wouldn't read as the dramatic evolution that it does. So at any rate, you should read the book because you'll like the book. It's a fun book. Now, before I go on, some of the people who may be watching this at home might be thinking, well, why the heck is there a book about the challenge to Obamacare when the challenge to Obamacare failed? So what's the point? We all know the Supreme Court, we know that the Supreme Court upheld the Affordable Care Act. So what's the point of a book that revives all the arguments against it that failed? Well, the news is, and people up here know, and many of the people in the room here already know, but out there you may not know, is that we succeeded, actually, in our legal arguments in the case, paradoxically. There were always two different issues at stake in this lawsuit. One was to save the country from Obamacare, and the second was to save the Constitution for the country. And by the Constitution, I mean the enumerated power scheme in the Constitution that says that Congress only has limited and enumerated powers. Both of these issues were always in play because the arguments that were being offered by proponents of the Affordable Care Act constitutionality, both the government and its academic enablers, were using arguments that would have virtually eliminated the enumerated power scheme of the Constitution. So if we'd have lost this case in a certain kind of a way, we would have not only inflicted this egregious and completely misnamed Patients Protection and Affordable Care Act on the country, but in addition to that, at the same time, we would have eliminated the enumerated power scheme that the Supreme Court has never repudiated in the history of this country, and that would have also happened. It would have been a disaster, a constitutional disaster, and that is what we avoided. We did not succeed in bringing down the entire act, although we weakened it in certain ways that may prove to be important in the future. But we did succeed in saving the Constitution by getting 5 votes for various legal positions that most legal academics thought were obviously mistaken. And so, in order to summarize that briefly, I'm just going to read 4 bullet points that come out of my concluding remarks in the book itself as to what we won in the case. It says, I said, we fought this case to deny the federal government the power to compel citizens to engage in economic activity. On this, we won. We fought this case to prevent the court from adopting the argument that Congress may adopt any means not expressly prohibited when it is regulating the national economy. On this, we won. We fought this case to prevent an end run around the limits on the commerce and necessary and proper clauses by using the tax power instead. On this, we won a partial but significant victory. Finally, we fought this case to establish that conditions on federal spending that constitute compulsion on states are unconstitutional, as Chief Justice William Rehnquist stated in his dictum in South Dakota versus Dole. On this, we also won. These were very important points of constitutional law, and to the extent constitutional law matters to the decision of the court, then we have established some very good constitutional law in the course of fighting this fight. So, in the time I have remaining, I want to make basically 2 different points. I want to cover 2 different things. One is about judicial philosophy, and the other is the role that politics played in the case. First, judicial philosophy. I'll say it very briefly. In part, the reason why we ultimately failed to defeat Obamacare in court, to the extent that we did fail to defeat the law itself, is part of the wages of crying judicial restraint that judicial conservatives of various political ideological stripes have been advocating for many, many years. It started with the political progressives arguing against the Supreme Court invalidating laws that were beyond Congress's power in the name of judicial restraint, and this cudgel was taken up during the Warren Court era by political conservatives, also arguing for judicial restraint. And what we now have is a judiciary that has in part been selected and chosen by Republican presidents and confirmed by Republican senates who have adhered or claimed to adhere to a philosophy of judicial restraint in which they will defer to what they consider to be the more authentic or majoritarian or accountable branches of the government, either Congress in the at the federal level or state legislatures at the state level. This has been a big mistake. It has been a big mistake, but one of the reasons why it was possible for John Roberts to save the law by adopting a saving construction, which was not what the law actually said, but another construction in order to uphold the law, was because he had behind him sort of the impulse of judicial restraint that had put him on the court in the first place, that had put other justices on the court. And it is almost a miracle that 4 justices who also got onto the court, adhering to various strains of judicial restraint, actually realized that at this point it was time for judicial engagement. It was time for the courts to say no to Congress, and this was certainly a part of its constitutionally delegated authority as a separate and co-equal branch of government. The courts have to say that a measure is within Congress's power without deferring to Congress's judgment that a matter is within Congress's power. So it's time, I think, in this country that we start selecting judges who are prepared to do their job in holding Congress to its enumerated powers, and unless we actually ask them to do that job, they're not going to. The last thing I'm going to talk about is the role that politics played in this case, because certainly it did play a role in this case. It plays a role in every major constitutional case, but I want to identify exactly what that role is and what, up till now, and what it might be going forward. One of the posts that came out in the book that I posted in response to one of Oren's posts is when I identify 3 different senses of what it means to say something is unconstitutional or constitutional. Because when we use the term constitutional, whether this law is or not, is not constitutional, it's ambiguous. There are 3 different things we could mean. First of all, we could mean what it is the Constitution says. Is it consistent with what the Constitution says and what the Constitution means? That's the old-fashioned way of doing it. That's the archaic way of doing it. But that's one way of doing it. And in this sense, there's no question that not only is the individual insurance mandate unconstitutional as violative of the original meaning of the text of the Constitution, but the entire act is. The regulation of the insurance companies themselves are unconstitutional, though we didn't challenge that, because insurance is not commerce under the original meaning of commerce. Commerce is the trade and exchange and movement and transportation of goods and people. All right, so that's the first sense. What does the Constitution say, and what does it mean? The second sense is, what has the Supreme Court said in the past, and what did it mean when it said that? This is constitutionality according to precedent, constitutionality according to what the Supreme Court has said. That is what we were debating on the blog, whether the Supreme Court's precedent said that this was unconstitutional, whether it said the law was constitutional or was somehow unclear, allowing this to be a case of first impression, which would require lower courts or the Supreme Court to now say whether this is constitutional or not, consistently with its prior decisions. So that's what the Constitution says, and what the Supreme Court has said, and what the Supreme Court meant when it said it. Now, the third sense of constitutionality is, are there 5 votes to strike down a law or to uphold a law? That's the third sense of constitutionality. Are there 5 votes? Now, when I'm interviewed by reporters about whether matters are constitutional or not, that's generally speaking what they want to know about. Do you predict that it's going to go down, or do you predict it's going to be upheld? And unfortunately, I think that's what most law professors, when they're quoted in the press, confine their opinions to. They predict it's going to be upheld. They predict it's going to be struck down. But that's really a separate sense of constitutionality than the first 2 senses are. And we need to keep these senses separated, in part because I do think it's the case that politics does enter into the third of these 3 senses as to whether there are 5 votes or not 5 votes to invalidate a law. As I noted early on in this book, in a blog post, those who were confidently predicting that the Supreme Court would never invalidate this law, I think were not taking into account the politics of the situation. They were assuming that the law, once it was passed, or after it was passed, would be popular. But what if it was very unpopular? The courts are very loath to strike down a popular law, but they're not nearly as hesitant to invalidate a law that's unpopular. What if not only the law was unpopular, perhaps, I say in there, one or both houses of Congress flipped parties as a result of this, and supposing that a serious repeal effort was made in the House that got filibustered in the Senate. Well, it turns out the Republicans didn't take the Senate, so there was no need to filibuster. They just didn't need to take up the bill at all. How would that affect the willingness of 5 justices to invalidate this law? I think it did affect the willingness of it. The Supreme Court of the United States is a very mainstream institution. It always has been, and it always will be, in part because of how justices are selected by the President of the United States and confirmed by the Senate of the United States. So there may be some justices who are kind of on the right side of that mainstream, and there's some justices who are somewhat on the left side of that mainstream, but you don't get to be a Supreme Court justice or even a Court of Appeals or district court judge unless you are relatively mainstream and you think mainstream. So it matters where the mainstream is. And this book and the blog post that took place, the blogging that took place in this book, as well as what happened well beyond this book, when the Heritage Foundation came out with its paper, and then there was a C-SPAN debate, and then talk radio picked up on this immediately as a result of the C-SPAN debate, and I started getting phone calls in my office after that debate was on C-SPAN asking me my opinion about this. Once that happened, by the time the lawsuits were filed in March, there was already an important public awareness of the constitutional questions that are raised by this case. I've never seen anything like it in my lifetime. I don't know that we'll ever see anything like it again, where the public's actually following district court proceedings way before the Supreme Court gets involved. And this politics is still working. This is the concluding remark I'm going to make. We would not have gotten so far. We would not have gotten 5 votes for the propositions I just read to you if it hadn't been for the fact that that was a relatively mainstream conclusion for the court to reach when it reached it. And going forward, there are other constitutional challenges that are still out there. There are challenges based on the interpretation of the statute, whether federal subsidies, for example, can flow to people who are participating in a federal exchange as opposed to state exchanges. There's a very important constitutional challenge about how this bill, which was a bill to raise revenue, originated in the Senate rather than the House, as the Constitution requires it to be. This is the so-called origination clause challenge that's currently pending in the DC Circuit Court of Appeals. Whether these lawsuits have any legs or not, whether they will get any tractions in the third sense of constitutionality, that is, can you get to 5 votes, will depend in important part on whether Obamacare, the Affordable Care Act, is popular or unpopular, and whether the court believes it is actually disrupting or interfering with the public good when it would invalidate it, or whether it would rather be doing the public a big favor if it were to invalidate this law, send this issue back to Congress where it belongs, and let's do health care right this time. We need health care reform in this country. It needs to be a good reform. This is not a good reform. I agree with what Trevor said. This was a way of doing single payer by basically making private insurance companies regulated public utilities. That's why they bought into it, because they get a lot of money out of it, but that's really what's happened here. And we're seeing the consequences now. And by the way, it's not just the faceplant that the law has done out of the tunnel as it's run onto the field. Just wait till it starts working the way it's supposed to work. Then you'll really see the problems with the Affordable Care Act that we actually put in our brief to the Supreme Court. So with that, I thank you all for coming. I look forward to your comments and questions.
All right, so I think we'll now turn to questions from you for the next 10, 15 minutes. I have 3 requirements. One is when you're recognized, please announce who you are and your affiliation. The second is keep it short and sweet. And the third is end it with a question mark. So with that, does anybody have any questions? Yes, down here.
Hi, I'm Andrew Kloster. I'm here with the Legal Center at the Heritage Foundation. So you've identified 3 or a number of good things that came out of this case. You know, the law was upheld on the one hand, but you've got the public, engagement. You've got blogs and things that are now engaged, and you've got a lot of good precedent. So my question is, on the precedential value of the case, have you seen any district or circuit court opinions where NFIB has been cited favorably for any of the good law that came out of the case?
Yes. One of the debates that occurred in immediate aftermath of this case is whether the material in the court's opinions with respect to the Commerce Clause and Necessary and Proper Clause is actually precedentially binding, because some claim, well, it's just dictum, it's not actually necessary to act when a decision is upheld as a tax. The counter-argument, of course, is that the Chief Justice's controlling opinion says that, in fact, this is part of the precedent, and he wouldn't even have gotten a tax issue had he not previously ruled that this is invalid as to the Commerce Clause and Necessary and Proper Clause, because that's what then led him to reinterpret the law so as to make it constitutional. And to make a long story short, there have now been several district court and court of appeals decisions which do in fact treat those parts of the ruling as binding precedent. There is one district court opinion to the contrary which said no, it's probably dictum, but on the whole, the lower courts are taking these parts of the decision seriously. So I think over time they will be seen as binding precedent, though obviously, as we discuss in the book, there are some points which are not fully clear there, like for instance, in the Necessary and Proper Clause, it's not entirely clear, well, how do we draw the line between a great and independent power versus a merely incidental one? That's something the court will likely have to consider in future decisions.
Randy?
Yeah, there's a very important implication of this case, which is so overwhelmingly accepted that I think it's not even discussed, and that is that the way the law was upheld by Chief Justice Roberts is the penalty to enforce what used to be an insurance requirement was upheld precisely because it was so low and reasonable that it preserved the choice or option of people to either pay the penalty or buy insurance. It wasn't coercive, and that's the reason it was upheld. Had this case been upheld as either under the Commerce Necessary and Proper Clause or even under the tax power theory that the dissenters on this issue on the Supreme Court had advocated, Congress, when that penalty turned out to be too low to actually get people to make the bad deal, to enter into the bad deals that Obamacare is making them enter into, by buying insurance that's vastly overpriced as a redistributive mechanism to pay for somebody else, when that penalty proves to be too low, had this law been upheld as a Commerce Clause regulation, Congress would have been free to raise the penalty as high as they wanted to get people in. They could have put jail time. They could have made it a criminal offense not to have insurance. They can't do that now. They cannot do that now. There's a Supreme Court precedent which says they can't do that now because they said this is only being upheld as a tax because it's low. It's a fine only, and it's low only. And of course, we could say maybe they could raise it a little bit. I'm not saying they couldn't do that, but they certainly can't treat this the way the drug laws are treated under the Commerce Clause and send you to the penitentiary for doing something that they don't want you to do. So that precedent is, I don't think there's anybody now who would deny that if Congress tried to do that, there would be a serious constitutional challenge, and there would be probably more than 5 votes to strike down such a law.
The interesting thing too is that the question of when they start raising the tax, which they will have to, in order to combat the increasing price of insurance on one side because not enough healthy people are buying insurance, there's theoretically some evanescent constitutional, heretofore not declared constitutional line where that becomes coercive. And it becomes the new baseline of like the South Dakota v. Dole for individual coercion. Because in the South Dakota v. Dole case, which is about state coercion, they said that 5% of highway funds was not enough to coercion, and then they went to this Medicaid expansion, which was enough for coercion. We have the same question now with how much you have to charge a person before you're actually unconstitutionally coercing them.
Other questions? Yes, down here. Can pass it.
I'm Jason Miller. I'm a law student at Catholic University, and I had a question in your blog debates and in the previous discussions leading up to the case. Did the religious freedom issues come up? For example, the contraception mandate.
They did, but they're not in the book, really. I focused the book on most of the Commerce Clause and occasional taxing power debates, but those are incredibly important issues. As we know, the court will be hearing that in March. I make a comment on that in the introduction because we always have this issue of if we resist the centralization of healthcare, we're supposed to be knuckle-dragging Philistines who are standing against the tide of history as everyone moves to spaceships and Star Trek world, and this idea that that's what we're doing, whereas the civilized way apparently to do healthcare is to bring it all to Washington, have every single religious group create an organization to fight it out like a bunch of tribesmen beating each other over the head with clubs. That's apparently what the civilized way is, and everyone needs an exemption. Who needs an exemption? From these things that are unconscionable as a matter of whether it's Jehovah's Witnesses or people who like crystals. Well, now you need a crystal lobbying organization. And you can make it of crystal if you want, but you still need one on K Street to get exemptions from things that you find unconscionable in the law. That apparently is progress.
That debate, by the way, is ongoing now in the Volokh Conspiracy, and Eugene Volokh has weighed in on that issue, so I would
Like
commend
50
it.
pages, yeah, it's really good.
There's a question down here.
Gerald Chandler. Do you think there'll be any spillover from the worries about NASA and government spying and so on to this case? That is to say, that are people getting more worried about extensive powers of government, and they don't want, there'll be a spillover to where they don't want the government to be able to control the health care?
One thing that hasn't happened yet, and I don't know when it's going to, and I hope it does soon, and that is the digital records, the medical digital records, part of not just this law, but previous laws. It didn't start with Obamacare. Means that you're not going to have to, the NSA is not going to have to monitor all our cell phones and emails to figure out all the illnesses we have. It's all going to be digitized and within reach of them, unencrypted or not encrypted enough to prevent them from accessing it. And so every illness you've got and every doctor you've seen and every shrink you may have talked to is going to be something that the federal government has access to because of this mandated digitization of all our medical records. We haven't got there yet. The public has not focused on this. Even the intelligentsia has not focused on this yet. But I think that the NSA surveillance issue, once this other thing, it could very well spill over into this aspect of medical care.
Yeah, and one other thought. One thing that I think made the Obamacare case unusual and remarkable and really gave it legs was the fact that it aligned so neatly along political dimensions. And Randy was suggesting this when he was talking about how the sort of broader role of politics played into this, and I think I would have put it, even more starkly. It became the idea that Obamacare was unconstitutional became the Republican position, right? It was just everybody who was a Republican would speak that way, and as someone who looked at the precedents and said, wait a minute, I think they come out the other way, I had a lot of people say, I didn't know you were a liberal. I was like, I'm not, this is what the cases seem to me to say, and people look at me funny and go,
He's a witch.
well, that's strange, I didn't know you were a liberal. So, and that was a case where really there was very much a sense, and this was part of a plan, right? This just sort of didn't happen accidentally. It was very much part of a plan to make it a partisan issue so that you would have, sort of open up possibilities for folks that otherwise might not have looked at it that way. And on issues like the NSA, there's still very much a division in both political parties, which I think keeps that narrative from happening, at least so far.
I also think just one little point too. One parallel more thematic is that my former colleague or former Cato employee, Radley Balco, who writes about police abuse issues of cops breaking into your house, has one of my favorite quotes from a libertarian standpoint, which is, libertarianism happens to you, which is you might not be a libertarian until the cops are breaking down your house. One of the things about these laws that we're seeing is that you can ignore government easier on a new little tax, a new little regulatory agency that's probably affecting businesses more than you, telling businesses what they can sell, but not so much individuals if you're not in business. But the NSA is directly affecting individuals in a way that people are starting to realize, and the mandate is directly affecting individuals. And suddenly libertarianism is happening to people more than before.
Ilya Shapiro from the Cato Institute. I want to ask a completely different question, not necessarily about the Obamacare litigation, but how did this episode and the role of Volokh Conspiracy in it affect legal academia, in the sense that, it used to be that if you were blogging, that was, not only was that useless, wasted time, but it counted against you, that you're not a serious academic by doing this. And obviously, all of you who are academics on the blog are very successful. Is this an anomaly? Is it kind of now becoming part of, if you want to be at the highest superstar reaches, at least for a certain generation, if you're under 50 or something like that, under 40, whatever the case may be, that you do have to make an attempt to join one of these group blogs and somehow start affecting the debate both in the public and have judges reading your blog and things like this. So what kind of effect is this book? Is, I guess, the highest example of it. Does this sort of thing change the way that law professors and the intellectual debate works?
So I think there's been a change brewing on this for some time, in that early on, a lot of people said, especially early in my career, said, well, maybe it's not a good idea to blog because people will say, well, you're not actually serious about your academic work if you're spending your time blogging. Now, at one level, this would still say, well, why is it any worse to spend your free time blogging to spend it going out fishing? But the issue is that when you're blogging, people can actually see that you're doing it, whereas when you go out fishing or whatever, unless the other law professors happen to be at that particular stream, they won't see you. Now I think you rarely see or hear comments that before, is even though there's a debate going on about whether blogging itself can, in a sense, count as scholarship or not, and you can argue about whether it can. I think actually most blogging is not scholarship, but even those like myself who don't believe that blogging is somehow a substitute for scholarship, they will no longer argue, most of them, that blogging is just sort of a waste of time and that it shows your unseriousness if you're an academic and you also blog, because they recognize that it's influencing public debate. And obviously it's not just the Volokh Conspiracy. There are prominent left-wing academics who also blog, most notably at the Balkanization website, which sort of held down the other side of this debate during the ACA litigation. So I think over time, and this will happen even more in the future, legal academics and also other kinds of academics recognize that blogging, even if it's not scholarship, is akin to other public intellectual activity that academics can legitimately engage in, such as writing op-eds. I would actually argue, having written many op-eds, that blogging in many ways is better because you're not so tightly constrained by the word counts and forms and other constraints that newspapers have, whereas in the blogosphere, it's much more flexible and can happen much more quickly and much more efficiently.
Yeah, tweeting won't work.
Your blog posts count as scholarship. He's the master of the 3-part blog post. So every 3-part blog post, yeah.
Randy?
There's a really important point to make on the subject, and that is that the reason why our blogging was as effective as it was, and the reason why this book is such a great book, is because we were all scholars in the field we were blogging about first. That is, we drew upon our scholarship and knowledge to make the more pithy, short-form arguments that we were making on the blog, as did our adversaries on balkanization and other places. I mean, one of the sort of interesting juxtaposition is Orrin was not so much a scholar in the Commerce Clause enumerated powers area as I had been and others of us had been, and he was kind of the protagonist, raising questions about, well, what about this and what about that, moving into the area. On the NSA surveillance, Orrin is the big expert. Orrin is a scholar of the Fourth Amendment. He is the real expert on that area. I am somewhat entrenching into his field as I raise questions about the constitutionality, the dubious constitutionality of the NSA bulk data collection programs, but I certainly know the difference between being a Fourth Amendment scholar and not being one. And so I do think that it will be a big mistake in our business if somehow our colleagues were to think that blogging is scholarship. Blogging is not scholarship, and it could be, I suppose, if you I know my colleague Larry Solem has legal theory blog. That actually almost amounts to scholarship. It does amount to scholarship, but that's totally unique. Generally speaking, we are just utilizing the knowledge and expertise we have developed in real scholarship in the sense of law review articles and books, and we're putting it to use. What blogging does allow us to do, though, is learn how to write better than we might have written in the long-form law review articles. And I couldn't get an op-ed placed in a newspaper until I started blogging because I kept writing in this sort of kind of inverted way that would not appeal to newspaper audiences. And once I started blogging, I got a different voice, and then I was able to publish op-eds. So it does enable us to reach a larger audience with our blogs if we develop the voice that allows us to do that.
Orrin, you had something you wanted to say?
Yeah, I agree with everything Randy just said. I would also say, though, that I think blogging is still a somewhat unusual thing for academics to do, and it's that in some ways it's surprising to me that for the influence that blogs are having and for the profile that they have, given the readership of them relative to law review articles, it's still a pretty small number of academics that are doing it on a regular basis. There's a decent percentage that maybe have their name on a group blog somewhere, and once a year or something like they might say something. But the number of people that are doing this on a regular basis is still really quite low. And given the hierarchy that I think legal academia tends to naturally favor, I'll think blogging has become a really established part of the legal academia when I see the junior professors at Harvard and Stanford and Yale sort of naturally start blogging once they get hired, and I think we're pretty far away from that.
Last question from this very patient gentleman over here.
Well, much of the conversation has been about the Commerce Clause.
Please announce who you are.
Oh, I'm Chris Conlon, and I'm with the Senate. But a lot of the conversation about the Commerce Clause, there was also some about kind of Medicaid and the coercive power on the states. But there was another issue that kind of come up, and actually it was in the Senate Finance Committee version. Orrin Hatch had actually raised the question of direct tax versus indirect tax. And of course, Roberts did address this somewhat in his decision, although I don't feel like it's really takes it on that really well. But Hatch's was based off of a article that was in Tax Notes, which argued that it was a direct tax and had to be apportioned, so therefore unconstitutional. I was wondering, did you guys look into that issue anymore? Do you think that maybe you should have raised that issue more with the court? That maybe that would have been with Roberts and.
Well, it's a good question. I mean, in our briefs, we did deal with the issue briefly because it was not an issue that that had been given wide attention by other judges at BFLO, and so we didn't think it was going to be a major issue, but we did in fact address it in the NLRB brief. I mean, in the, not NLRB, the NFIB brief, sorry, which I worked on. So we did raise it, but here's the thing I think you have to keep in mind, and I agree with you that the treatment of this issue by the Chief Justice was highly cursory. And sort of an afterthought. And part of the reason is that there was no oral argument on the issue. There was no adversarial briefing on the issue. You shouldn't be making law on an important legal question like that without the adversary system working, so you generate good arguments on both sides, and then you be able to test those arguments in oral argument. None of that happened because it was a side issue that didn't go to that was never really raised. And so it's another reason why I think what the Chief Justice did was a mistake. It was actually complained about, I think, by the dissenters on that issue as to the fact that he reaches this issue without briefing and without full attention to it, and made maybe bad law to the extent his one opinion is law. But it goes to another issue that I noticed that I think I said here in one of my blog posts, and that is, when you learn as a litigator in court, whether you're a prosecutor in criminal court or whether you're doing constitutional adjudications, you cannot make a judge rule the way the judge does not want to rule by arguing against them a certain way. That is, if a judge really wants to reach a certain conclusion, there will always be reasonably decent arguments they can rely upon in order to reach that conclusion. So it's not a matter of, well, if we'd have just made this one argument, we could have stopped Chief Justice Roberts from doing what he was bound and determined to do. For whatever reason, he was bound and determined to do it. It wouldn't have stopped them. It actually could have made things worse. We made bad law on this little tiny corner of tax law rather than making bad law in a much bigger way. Maybe it would have forced him over to really side with the dissenters on the big picture questions that we won on. So, in fact, you can't think of a lawsuit that way. You can just make the arguments you can make and make it as costly as possible intellectually for a judge to rule against what you want them to rule, but you can't stop them from doing it.
One comment on the tax thing generally, and that is, it wasn't just this part of the tax argument that was somewhat underdeveloped, it was the entire thing, because in the lower courts, the tax argument was uniformly rejected, not just by those judges who struck down Obamacare or struck down the individual mandate, but by those judges who upheld it on other grounds. And if you look at the transfer to Supreme Court oral argument, not just the conservative justices, but even the liberal ones expressed tremendous skepticism about the tax argument, and the Solicitor General arguing the case for the government. I don't think he really expected to win on this argument, because if you look at their brief, it's relegated to the last 3 or 4 pages of about a over 50-page long brief. If you're an experienced appellate lawyer, that's where you put like sort of the throwaway arguments that you don't think are actually going to influence the court, but you might as well make it anyway because have some additional space, and you never know what might happen. So I always thought, and most experts thought, that this was by far the weakest of the 3 rationales that the federal government offered for the law. So also what happened is either Chief Justice Roberts had sort of an idiosyncratic reaction where he was almost the only person, or at least the only expert in this field, who rejected the commerce and necessary and proper arguments but bought the tax argument. That's possible. There are idiosyncratic people. Or, as various press weeks suggest, he had a sort of political motive in that he thought that this was necessary to uphold the law somehow to preserve his reputation and that of the court. And in his view, the tax argument was perhaps the least damaging way to do it because it was the least expansion of federal power beyond what it had been previously. So at this point, we can't rule out either the idiosyncratic interpretation that he genuinely believed this argument could have been the case, or the sort of more political interpretation. But whatever the case may be, this came very much as a surprise both to us and I think to most common. Whereas the other arguments offered by the federal government, which were much stronger, ended up losing.
Well, this really terrific book is for sale in the lobby, so I hope that some of you will avail yourself of the opportunity to purchase it. You won't regret it. And please join me in thanking our panelists.